Hello, everybody. My name is Sami. I'm the CEO of CertiCraft. We are on a mission to help craft cannabis growers transition into and thrive within the new regulated market. This is the State of Craft series. It's a podcast series. It's intended to facilitate discussions on the craft cannabis industry and to bring in perspectives of all kinds, be they growers, craft cannabis associations, or in this case, lawyers that have fought the good fight for this industry. It is a pleasure to introduce John and Jack today. I'm going to introduce them in a moment. I just want to do a few housekeeping things first before we get started here. For everybody in attendance, we have a chat where you can say hi and have share any comments you might have. There is a separate dedicated questions section. If you have any questions for Jack, Lloyd, or John Conroy, please go ask them there. We will have a dedicated Q&A portion at the end of this talk. And without further ado, I'd like to introduce to you the inimitable John Conroy and Jack Lloyd. John and Jack, do you guys want to maybe each give us a brief 30 to 60 second intro on who you are and anything you feel is relevant to share with this audience that we have here today?
Okay. I'm getting old, so I may forget things, but I was called to the bar in 1972 and became involved in this issue to a certain extent by the mid-70s. In terms of incorporating NORML Canada, I was working with the US NORML and people like that at the time, and that was when, people were getting busted, but it wasn't as intense as it became later on. And so I've been involved in this issue basically since that time, whether on the political sort of end in terms of NORML and chapters and things like that. And you know, every time you defend anybody in the courts with a cannabis thing, especially once we got the charter in 1982, we had some ammunition to try and raise more defenses. And so we also I was counsel for Randy Kane in the Kane Malmo Levine case that went to the Supreme Court of Canada challenging prohibition generally. And then I was counsel in Allard, which was the medical cannabis case that was through federal court and which they didn't appeal. So I've basically been involved in the whole issue, not just in terms of cannabis, although that was certainly a major focus, but I was also counsel in the supervised injection site case I acted for VANDU, the Vancouver Area Network of Drug Users. So my whole attitude has been anti-drug prohibition, taking the position that I think it has made things worse instead of better, and that the use of the criminal law and prohibition is simply a stupid approach to trying to regulate people's use of different types of drugs. And no matter how much overwhelming evidence there is, governments don't get it, or maybe there's another reason.
Mm-hmm. Jack, I think you are muted right now. I see like a microphone. Oh, there you go. You got it.
Yeah, there was a fire truck going by my house, so I muted. And John is also the founder and president of the National Organization for the Reform of Marijuana Laws in Canada. And now, he was the president since 1978, I think. And now he is counsel to NORML Canada, so he's our lawyer. I have the good fortune to act now as the president of that organization, and I've been volunteering with them since 2011, I think. I'm also a lewyer, and I just a lawyer that has the good fortune to work with awesome people like John Conroy and Kirk Tusaw and Paul Lewin. And I've been advocating cannabis legalization for most of my life, and also worked with as an editor with Green Candy Press, which is the world's largest publisher of books about the cannabis plant. So that's my my background.
Cool. So, to the audience today, we're going to do things a little bit differently than usual. We're not going to jump right into a discussion. Instead, first, we've asked John if he'd be willing to share a brief history of cannabis from a legal perspective in Canada, and how prohibition has come to be, and kind of the journey that's been going on since then. We were having a discussion before this started, and he kind of started giving us this history, and it was such a wealth of knowledge, and we thought it would be pretty sweet to kind of have that be shared with our audience at large. So, John, I'm going to full screen you here and kind of give you the floor for, I don't know, maybe 5 minutes or so, and let you take us on a journey, and then we'll get into the discussion after.
All right. Well, I think it's important for people to know that the drug prohibition basically started in the early 1900s as a way to get rid of the Chinese. The Chinese had come here and built the railroads, and had a large community, especially here on the West Coast, including down the West Coast of the United States. Similar things were happening there. And so Mackenzie King was Minister of Labor, and they passed the first Opium Narcotic Act, 1908. The Opium Act actually was the first version. So if you go to the Dominion Annual Review of Statistics, and I'm talking again 1908, 1905, 1908, in that period, you'll see Chinamen deported possession of opium products. So it was a way of controlling immigration and labor unrest and all these sorts of things, because white people were saying that yellow peril was getting women in the opium dens in Vancouver and so on and so forth. So there was this whole racist base. It wasn't then until later in the U.S., the Mormon situation, where many Mormons had gone to Mexico, had picked up the habit, brought it back, and then there was a big fuss in the Mormon church about people using cannabis, and they were the first U.S. state to make cannabis illegal, and that was around 1910 to 1915. And after that, there was another group of U.S. states, the Rocky Mountain states, that so Texas, New Mexico, Colorado, Montana was the next group. And then after that, the third group was Connecticut, Rhode Island, New York, New Jersey. So these groups of states that were passing state cannabis law. Don't forget, in the U.S., criminal law is state run. It's not federal like ours. And so you had individual states doing this. And that's around that time, our first magistrate, Emily Murphy, under the name Janie Canuck, wrote a book called The Black Candle. And while some people dispute that this was part of the origins of it, nevertheless, this was serialized in Maclean magazine. So our parents and grandparents and so on, this was the reefer madness that was spreading across the country at the time. We didn't have people being busted for cannabis. I think later on, we had a few, and there were significant penalties, mandatory minimums, and everything back in those days. But essentially, in 1923, because the Opium Act, which had become the Opium Narcotic Act, and which had a schedule, you'll see they added cannabis to the schedule. There was no real fuss. There it was added, and it became unlawful. And so we had a few people from time to time being busted and getting serious penalties for cannabis for some considerable period of time. But it wasn't really until the 60s when there was this huge interest that took off. And that in turn led to, by then it had become the Narcotic Control Act, and eventually it became the Controlled Drugs and Substances Act. And so it was under the Narcotic Control Act and Controlled Drugs and Substances Act that I handled most of the cases I was involved in. And then, as you know, since October of 2018, we have the Cannabis Act separating it from the other drugs. Still, though, a use of the criminal law by Parliament, which I think is one of the problems. But in any event, we now have a little bit of legalization, still quite a bit of decriminalization, and still quite a lot of criminalization. The statute basically has all three. The decrim is the ticketing scheme. So we've come a long way, but it's taken a long time.
Thank you so much for that, John. And so, yeah, now I want to kind of turn the floor to both of you, and we'll get into this discussion period here. And just to clarify, the whole point of today is to understand both of your perspectives on the state of the legal craft cannabis industry today. What you see as being good about it, what you see as being problematic, what are things that you think need to take place in order to solve some of the issues that you see in there. So with that context in mind, I'm curious what you guys both see as being done really well, if there is anything at all, by the Cannabis Act, the cannabis regulations, and the legal state that we find ourselves in over the past 2 or 3 years since the Cannabis Act was passed.
Well, if you want me to start off, I mean, I think we've at least turned the corner by it becoming legal. And so that, for most people, being able to possess up to 30 grams and grow 4 plants of any size is pretty good. And you can now buy it in stores, and you for some time, if you're medically approved, been able to produce for yourself or acquire it. And so things are moving in the right direction. But as I mentioned earlier, they're still using the criminal law. And so, it's an attitude that's been there for so long that I see as the major problem. Instead of rolling everybody in who was involved and saying, look, we know you're involved, but we're rolling in, we're legalizing. And what did they do in alcohol with the Bronfmans and Seagrams and so on? They didn't push them out. And so instead of saying, look, we forgive you, or you're immune or whatever, and rolling everybody in, if there's a real concern about, they always go on about diverting to the black market. Well, the whole objective is to get rid of the black market. You don't do that by pushing people out. You do that by rolling them in and encouraging to come in. And so I think that's the major problem, is that they've kept pushing people out and not making them see that they're welcome and to, if there's a problem, as I say, you say to the person, we know your history, we know your background, we don't want you to associate with this person or that person. Parole boards and judges in terms of probation do that sort of thing all the time. So why can't we do that to regulate an industry that we are trying to legalize? And, the legalization has certainly changed a lot of people's attitudes, and I think we've educated people, but we've still got that darn criminal law thing hanging around there that's creating a problem. I just read some stats that said, we're making big inroads, the legal market is up and the illegal market supply is down, but I don't really know how they really can figure that out, because those of us who've been around a long time know that there's all sorts of people out there who've been acquiring from good craft producers over many, many years. And like any ordinary consumer, they're going to keep going to what they think is the best quality product that they're used to. That's just going to be human nature. They're not going to switch unless they didn't have a good source to start off with. So I suspect a lot of the stats are new people coming in, seeing how good it is, overcoming their fears. And all of this is, history is going to take time to do it, unfortunately, very slowly, but we're in the right track.
And the stats are pretty funny, I think, because when Stats Canada puts out their statistics on sources of cannabis, because we've used that in our research internally at CertiCraft, what they do is they actually put out surveys to the general public in Canada, and they ask people, where do you buy your cannabis? How many Canadians are going to tell the government that they purchased their cannabis illegally? That's an actual question that's being asked to people. And it was funny because in 2019, when the first big survey of that sort came out, the number was at 70 or 60%, somewhere there, if people purchased their cannabis from illegal sources. And what that number tells you is 60 to 70% of the public was willing to tell the government that they purchased their cannabis illegally, which means the real number is going to be so much higher than that. And I don't know if the way that they're getting their statistics now are the same way, but if they are, I would very much take that with a grain of salt.
Well, it's so interesting to me, those exact figures, because I can recall the exact sort of census data that you're referring to, and they were saying, and look at the size of the illegal market, and there was, I don't recall the number, but say it was $2 billion or something, and they just recently the size of the legal market, which they described as a fraction of the total market, was significantly larger than that. And I was kind of doing the math in my head, and it felt as if there was, as a consequence of legalization, there was actually an increase in the market of the illegal guys. It was quite surreal. So I think you're right that there's some funny numbers going on with the assessment on legal and illegal cannabis.
Well, it's very interesting because of, the government has been dragged kicking and screaming through the courts primarily to get to this stage, and to a great extent with the medical. And so, I think they made this major mistake. In a way, maybe not a mistake, but they said you've got to grow your own or have somebody grow it for you, and they didn't have a supply. So what are people going to do? All of a sudden, we had way more people learning how to grow or grow for other people. And so you had this plethora of grow-ops, as they called them then. And, again, they were dragged kicking and screaming into coming up with a legal supply. And so when you look back at the history, now they're trying to stop everybody from being craft. But hey, you created the craft. You encourage people to be craft. I mean, for the longest time, Health Canada would say, go get your seeds from the Compassion Club or from one of the existing people, So they create the situation and then they try to undo it, instead of understanding human behavior and trying to regulate it instead of change it, They don't use as I say, the carrot as opposed to the stick approach, which is far more effective. And using the criminal law is just the most ridiculous thing.
And John, what do you think about the security clearance issue? I think that's most palpable in the craft scenario, where people that are in a position to start a garden that's craft sized are most often people that have experience in the black or gray markets. Do you think that the security requirements need to be relaxed?
Oh, they are the best example of the continued criminal law approach that the people in the government that are doing these have. You were seen at Kitts Beach in Vancouver 10 years ago, standing around a car. Somebody complained about the smell of cannabis. The police came, told you to move along, but they took everybody's name down, so you're now in a digital database. So you apply for a security clearance 10 years later. They say, oh, you were, they repeat this. And they say, we fear you're going to divert into the black market or into an illicit activity. And you say, but, these are real cases, real facts. And I've got one guy who's got a huge history because he went to kindergarten with people who are now Hell's Angels and things like that. So he knows all these people, but he's never been in. He's got no criminal record.
Because he went to kindergarten with people who eventually became gangsters.
He associated with them. He had lunch with somebody who was charged with a criminal offense. Nothing about whether he knew if the person was charged with a criminal offense. Usually you're presumed innocent if you're charged with a criminal offense. I didn't know you couldn't associate with somebody who was charged with a criminal offense, or that would again be used against you. So, I really have trouble, and I've got a bunch of these pending. Some of them are finally being approved, but we've even had to go to court on some of them. And it's problematic because the best you can get in court is a reconsideration. So they send it back to Health Canada to redo it. And I've got one in which they agreed to reconsider on the eve of the court case was to be heard. And so we said yes. And it took them 6 months to come back with the exact same decision. So, and now the big fear is they're going to do this to medical people because if you've seen this guidance review document, the criteria, sure, if you're medically approved, you're eligible, but they still have this ministerial power to reject or not accept you because they fear you're going to divert into the illicit market. Well, so are we going to now have people who have applied or are renewing their medical licenses being subjected to the same test as a security clearance? Now, there's a big distinction, of course. A security clearance has been declared as a privilege, not a right, whereas we know in terms of the medical, that the medical exists to prevent the violation of people's constitutional rights to the security of their person. So there's going to be that issue. But in the Supreme Court of Canada years ago, I did a case called Martineau, which was a prison case, to establish that if somebody's going to impact your not just rights, but privileges or interests, that there is something called the duty to act fairly. And that is that you get to know the case against you, or enough of the case against you, so that you can fairly respond. Well, what happens with these security reviews, and is maybe going to happen with the medical, is they go to the police, and the police produce something called a LERC, a law enforcement record check. And even though that document says we can't verify the information in it as reliable and credible and so on, or words to that effect, Health Canada, that's the document that'll say, well, you were seen with the car 10 years ago, or this or that. And often it's subject A or subject B. In one case, it's K through Z. There's all these people he's supposed to remember he had dinner with 20 years ago, or 10 years ago, or even 5 years ago. So, the law is you need to tell the person enough, not just who's subject A, who is subject A. Don't make them guess, and give them a fair opportunity to respond. But I think what we're saying is we really shouldn't even have to get to that. What it should be about is, okay, we know you've been growing before, we know you're associated with this, or we know you've got this criminal record or whatever. Here's your license. Here are the conditions. We've added some special conditions because of some concerns we have. If you screw up, you're going to get your license suspended and revoked. Let's go.
So question for you, as I'm somebody who does not understand the world of law to the extent that you guys do clearly, and I'm going to assume that a lot of the audience here as well does not have the kind of understanding that you guys have. So, you've brought up a few times now that one of the big issues that you see is treating cannabis still within the criminal law world, and kind of having this adversarial approach instead of really trying to bring people in. At what level of government, at what level of law is this problematic? Is it literally every level, from the legislators that created the Cannabis Act down to Health Canada enacting the policies? Is it more like fully in Health Canada's hands to create regulations that aren't so adversarial? Like where does this change need to take place? Could you give us an understanding of like the more technical aspects of how a law gets created and how a change like this can take place?
Well, criminal law is federal in Canada. Mm-hmm. And so the drug laws were passed under the criminal law power, which is a broad power that the federal government has. The provinces have powers in relation to the administration of criminal justice, so some of the judges and courts and so on. But health is a divided power between the feds and the provinces constitutionally. So you've got elements of both. But I think rather than get into the technicalities of that, I think the straight answer to the issue is it's all levels of government that are still a problem. The feds, because they control the Cannabis Act and regulations and these issues that we've been talking about. The provinces have been given the power to distribute, so you've got all of the dispensaries. Distribution is controlled by them. And then you have local government. And local government, cities, regional districts, and so on, they have all their own bylaws and things. And so, as an example, where I am in the Fraser Valley, I'm part of the Agricultural Land Reserve, but the Agricultural Land Commission has basically said, yeah, okay, cannabis is a farm use and they can't prohibit it, but you can only do it in soil or in a greenhouse or in a building that was made prior to June of 2018 or something. And so, ironically, because of local people who are still, in the fear of cannabis, that the reefer madness you see still at the lower level, at these local government levels. And so they impose these restrictions. And the irony, of course, is that if you're going to force people to grow in soil or in a greenhouse, they are going to stink out the neighborhood. Or maybe there's going to be nuisance from the light from the greenhouses or whatever. They don't understand that to try and prevent nuisances, you need to allow people to also be able to do it indoors and process it and so on. So, I mean, all levels of government, I think, some are very good and are looking at it very well. I mean, in our, again, to use the Fraser Valley, we've got 8 regional districts, and I think 5 of them are supportive, but 3 of them aren't. So the 3 that aren't are the ones that are, even though you're in a farm land, are preventing you from basically doing it. So, yeah, lots of rules and regulations at all levels.
Jack, do you kind of have very similar sentiments all around to the general perspective that John's been sharing so far? Is there anything that you feel differently about, or any nuances you want to bring to the table that you think are important?
Well, as always, I agree with John, certainly. I think I would echo John's point in regards to the criminal law, but what sticks out for me, I think, most palpably is, like, they've used the criminal law power to regulate the entire industry across Canada, which is really peculiar. The criminal law power is not an industry power, right? That's not like a money-making power. It has justice-oriented purposes. So it's really, like, cannabis legalization is very interesting in that regard. But I think what stands out the most for me, and it relates to craft, I think very palpably, because so many people that are interested in craft cannabis come from the cannabis industry before it was legalized, right? And so they face this enhanced security screen process. And I think really what's going on is that they're getting the negative aspect of the criminal law, right? And not the good aspect of the criminal law, which is the presumption of innocence and the strong procedural protections in place for an individual's rights. It's very difficult to find someone guilty of a criminal offense. You have to prove beyond a reasonable doubt they did, in fact, do whatever it is you allege that they did. With cannabis legalization and the administrative security process that they've put in place, and so much of my knowledge on this comes from John, like, my view of it is that they get none of the benefits of the criminal law system in which you're presumed innocent, and all of the negatives of the administrative legal regime in which there's, I would say, there has been a gradual erosion of personal rights in that regard over the last 20 years. And so, that's my deepest concern for the craft. And I don't want to be, like, myopic on that point. Like, I've had a number of clients with criminal interactions and things that I've managed to get through the security screening process. But I agree with John that really they ought to be saying, look, we're giving you your license, and here are the rules of the license. And if you don't follow them, and we're going to watch that you do, we'll suspend you or take it away. That's the proper use of administrative law, right? Like, the government, the feeling for me is that the government is using, administrative law as to do an end run around the criminal law protections, that the procedural protections associated with criminal law generally, and it feels wrong to me on a lot of levels, because if you're going to use the criminal law, we have serious procedural rights and protections associated with that for a reason. You are presumed innocent.
If there are these rights that you're talking about, if you are, according to criminal law, supposed to generally be presumed innocent until proven otherwise without any kind of doubt, is there any kind of legal ground to challenge the government on the way it's implemented the cannabis regulations and all these security clearances, or are they, despite it being wrong on an ethical level, is it still fully legal within the Canadian systems of law?
So there's a new case. John's the guy to talk to on that, because he litigated it. But John's going to tell you about a case called Vavilov, I'm sure, and about procedural fairness. That'll be. I'll just say procedural fairness, and then John can talk about that.
Well, it actually started with a case called Nicholson that involved the disciplining of a police officer. And that actually established or brought into Canadian law, or affirmed in Canadian law, this duty to act fairly, which is at a minimum a procedural requirement. As I mentioned earlier, the case against you, know enough about the case against you so you can have a fair opportunity to respond. So, for an example, subject A, you were seen associating with subject A 6 years ago, or whatever. government, the police put that in the lurk, and you say, well, who is this person? They say, well, we can't tell you because of privacy. You say, but you're accusing me of associating with this person. Surely you got to tell me the name so I can respond, So they use the Privacy Act and all these sorts of things to block you. I mean, that's not going to happen in a criminal case unless you're faced with a confidential informant that, whose name can't be used or whatever. So it is this problem. Now, sure, I see what Jack's saying in terms of the criminal law, and I agree. If you're going to threaten people's liberty and the security of their person and stuff like that, then, at least the charter is there, and it's an entrenched constitutional document that you can rely on, whether it's criminal law or administrative law, if your rights, privileges, or interests are in some way being affected. And so I like to see, the shift out of the criminal law totally into administrative law. Like, Jack mentioned Vavilov. When we took the Nicholson case in a case called Martineau No. 1, and we went to the Supreme Court of Canada actually twice to establish the duty to act fairly in relation to prison disciplinary matters. It used to be that the prisoner, the staff member would accuse the prisoner of something, and his superior officer would be the judge who would decide whether to believe they're his inferior officer or the prisoner. And it was just, a kangaroo court. And then they had disciplinary courts, and we managed to get independent people in and so on and so forth. So it was a long history of fighting to try and make sure that people at the bottom of the rung in prison, that the rule of law applies to them and that they too are entitled to the duty to act fairly. And so from that, there's been many cases that evolved, and Vavilov is the most recent one that the Supreme Court of Canada has pronounced on, because there's always these refinements of just exactly what's required. And the ultimate test in administrative law, Jack mentioned in criminal law, it's proof beyond a reasonable doubt whether you committed the offense. In most civil cases, it's proof on a balance of probabilities as to whether this or that happened. In administrative law, the question is, did the person who's affecting your rights, privileges, or interests act in a reasonable manner? Was it reasonable? And so the courts have defined what that means. And it's not just an easy definition. It doesn't involve
such a vague and open-ended term.
Well, yeah. So they've refined that to mean, do the reasons make sense? Are they internally rational? Are they, so it's quite an interesting test, and we've seen courts look at some of these decisions and say, that doesn't make sense. What you're saying doesn't make sense. But we've also had some in the security clearance one where the court seems to accept the government's position without question. So it's a business of trying to make sure that they do tell you the case against you in sufficient detail so you can respond to it and show, your side of the story, and that they do it, and so that the decision maker does make a full, reasonable, understandable decision, and it isn't, because 10 years ago you were around the car and the smell of pot and marijuana, therefore we think you're going to divert. It's more specifically like you were involved trafficking or something like that with somebody. And so we are, some real understandable basis for rationally saying we think you're going to divert into the black market, instead of simply because you happen to be one who was in favor of cannabis for the last 20 plus years or something and know lots of people in the cannabis industry. So,
so just to make sure that I'm 100% on the same page here. So in this case that you're talking about, the Supreme Court basically said that that's the definition of reasonable. You have to be able to prove that there has to be that kind of very clear connection. It can't just be there was a smell of cannabis around you once, so therefore you are a danger.
It's got to make sense. It's got to have an internal, realistic. It's got to be reasonable. It's got to be rational. So, why 10 years ago, hanging around the car with your buddies, how the hell does that have anything to do with a likelihood, It's simply people who are involved in cannabis. Is that enough to make it likely? Something more is required. So this is what we, grappling with to try and get the courts or the judges to do this with these various decisions. And as I say, it's going to be particularly acute if they start doing this in the medical approval situations.
And so on a practical,
concern,
go ahead, Jack.
Oh, sorry. I think the real concern, not only in the security clearance analysis that John references, but in the what appears to be the new approach to the assessment on personal use production licenses or designated person production licenses for cannabis, it is really what's going to happen is an unfettered discretion is being delegated to the Health Canada people, and there's like a serious potential for prejudice against certain applicants. And I think that's kind of a concern that we need to look really closely at. What do you think about that, John?
I wouldn't say unfettered. I mean, sure, they act as if it's unfettered at times, but the fettering is us imposing these limits on their decision-making powers, making them understand that they have to act fairly, and what that means, not just procedurally, in terms of making sure you know what they're saying and what the basis for what they're saying against you is, so that you can respond to it, but also at the end of the day, that the decision is substantively reasonable within the meaning of that term as a matter of law. And so it's not just some government bureaucrat saying, well, we think you're going to traffic or divert into the black market simply because you went to school with somebody 16 years ago who happens to be a Hell's Angel. We've got another case that says investigative reporting says you're associated to the Hell's Angel, and this fellow has sworn affidavits and stuff. What are you talking about? I have nothing to do with them. The only thing I ever had to do is once I went to try and go to some races somebody told me about, and they said it was a Hell's Angels thing, and so we left. And they used that against them. We said, well, what do you mean by investigative reporting? So it's an example of Health Canada not providing you with sufficient information to enable you to respond, other than say, look, it's not true. So if they added a bit more to that to show that the guy had in fact, and I say not just associated, but was involved in criminality, well, fair enough. That then provides some more substantive information. But at the same time, I'm still saying to myself, that's still much more like a criminal law approach, instead of saying, we know you went to school with all these people, or we knew you were hanging around the car and that these people. Well, are these other people involved in any criminality here 10 or 20 years later? Are they, why are you concerned so many years later? And why can't you simply address this in a very simple licensing manner without doing this thing that is, as I said before, pushing people out to compete instead of rolling them all in?
And how does this get changed? Does it basically take a court case that goes up to whatever level of court it needs to reach in order to say, hey, we have established precedent that shows that these steps need to be taken. This is pretty ludicrous that you are making these connections out of thin air. This is illegal to do this in accordance to that case that you brought up and the various cases that have taken place in the past. Like, is that like a realistic path? Is there an easier path to being able to change this kind of security clearance that exists today right now that is causing so many people to not be able to enter the legal market?
Well, first I should say that Health Canada says that most of the people who apply are getting clearance, and that I'm only seeing the problematic ones. And so it may be that, lots of people are getting clearances. So I think the answer is simply, yeah, we're going to have court cases going on that hopefully will refine and become definitive, so that we don't have to go to the Supreme Court of Canada, or maybe there'll be one Supreme Court of Canada case that sets out the basic rules and we'll forward it. But in terms of changing things, getting politicians to change specific legislation is a time-consuming, long time-consuming process because of the continued political debates between, the Conservatives and the Liberals and the NDP and so on, the politics of these issues, whereas we as lawyers are much more involved in looking at, those specifics to try and prevent people from being prejudiced by them and to get things to move forward. Unfortunately, it's a slow, incremental process, or at least it has been, and I expect it will continue to be. But I still remain optimistic that, notwithstanding the problems that are there and that continue, we're moving forward in the right direction. And over time, it takes a long time to get people to be educated and accept, as we know from many of the theories that are out there and with social media and everything nowadays. There's so much more kerfuffle about these issues and stuff that hopefully we'll get them sorted out through the process. But I'm not holding my breath for quick solutions.
I'm slightly less. I'm so interesting to me, but I think that the sheer fact that it's federally regulated using the criminal law power amplifies the stigma, and I think that stigma is really at the heart of this entire scenario. And in some ways, that's why I have kind of a negative view of the administrative legal system of these, unelected mandarins deciding the fate of the cannabis community at every sort of stage of licensing. I find it deeply concerning, and I view it as an erosion of significant personal rights held by, the members of our community. So, but I think John's quite right. It's just going to take time. But I do think that John's initial point that regulating it using the criminal law power exacerbates the stigma that's felt all the way through the legal system that affects someone trying to join the craft industry.
Mm-hmm. To our audience out there, we're getting close to the end of our time here before we shift to questions and answers. So if you have questions, do go to the questions tab and ask them. I'm not going to cut off the conversation right here because, John, I can tell you want to say something more.
Well, I was looking at the questions, but if we're getting to that, do you want me to address one of the questions?
If you feel like there's a question that's like really apt for where we're at in the conversation right now, feel free to go ahead. But I want to give you guys kind of a chance to wrap. The way we've done it before is we've had the long discussion, we've wrapped it up wherever the cadence felt natural, and then we've shifted to questions. If that is right now, if you guys both feel ready to enter questions and answer phase, happy to do that.
Well, I saw that Dave Hutchison raised the question about purging cannabis records and so on. And as most of you probably know, in Canada, they've simply say you apply for a pardon. And I think, and Jack maybe can correct me if I'm wrong, some of them are sort of like automatic pardons, or at least compared to the usual pardon process, where you apply and then somebody decides whether to grant you the pardon or not. And if you have the pardon, it's like being on parole. If you screw up, they can revoke your pardon. And so it really is just ridiculous to, all these people with simple possession records and so on in the past to use that pardon process. So expungement is the way to go. I mean, if you want to legalize something and stop it being used to prejudice people, you've got a record for simple possession. I don't know how many times I've seen how that or even a stay of proceedings, and sometimes even if you've been acquitted, they use that against you. So we got to get rid of this and get rid of it properly, so that people aren't prejudiced in many different ways in the future, not just at the border, but in terms of other, work and so on. So I think that's an important part of legalization, is wipe out the past because we're starting anew.
I definitely agree with John. His reference to sort of the amended pardons are just suspensions of criminal records, so that they can reimpose the criminal record at their discretion, whereas an expungement is a complete removal of it. And I frequently say this to clients, is that the federal government, in its infinite wisdom, has created a situation in which, in certain circumstances, you're better to be found guilty and absolutely discharged of an offense than to get a stay of proceedings or something else. And John wrote very eloquently about this in a wonderful article that really inspired me when I was first starting out as a lawyer. And it's so true that the discharge system mandatorily requires the expungement of all record of the situation. So that should shock Canadians to know that you're better off to be found guilty of an offense and discharged of it, absolutely, than to be found not guilty of that offense. That is you want to say Jack's crazy saying that personal liberties are being eroded. Look at that.
Yeah.
Well, as I say, and it's the digital database now. I mean, the article that I wrote was about the prejudicial consequences of a non-conviction. I was focused on stays of proceedings. How, when I first started practicing in the old days, if the Crown was going to drop a charge, we'd still come to court, we'd stand up, and the Crown would say, "We're calling no evidence," and I would invite the judge to dismiss the charge. And so the record would show that the person was found not guilty. It was dismissed. Then they realized that they didn't have to come to court. They had the stay of proceedings power, which I don't think was really intended for this purpose. It was intended if you're thinking about reinitiating. But anyway, so they would just stay the charge. And everybody would say, "Oh, the charges are stayed. The charges are stayed. They're dropped." But, you go to the border, "Oh, stay. That can always be revived." You go to prison, and you're in front of the parole board, and they say, "Oh, you've got this record of all these stays of proceedings." How involved you were in criminality, even though you weren't convicted. And so that's evolved. Now they don't even have to charge you or stay it. It's simply, you're in the digital database. The policeman has put it into the digital database. So again, the security clearance thing, up comes the lurk with all the digital databases, intelligence, and it's because the legislation actually talks, instead of it being limited to convictions, it talks about or events. And so any event that they come up with in the digital database, they then try to use against you. And that's, a huge, I think, problem in terms of prejudicing people in many aspects of life, not just on these issues we're talking about.
But before we get into the last two questions that we have here, I just want to get a sense from you guys. Today's big topic was these issues around the way records that are very loose from the past are being used to determine somebody's fate as to whether or not they can even get a license through these security clearances. Are there any other big issues that you think really need to be addressed? And sorry, I should backtrack, but there's also the whole fact that it's criminal law being used to enact cannabis legalization in Canada. That was another big topic of conversation. Are there any other big issues on a legal level that you guys that we haven't touched on here today that you guys think are really critical and need to be addressed in order to facilitate a thriving and healthy craft cannabis industry here in Canada?
I think on the international stage, the regulatory oversight and the system for its enforcement in Canada is potentially making it hard for us to be competitive as other nations enter the legal sphere. So, I do think, that's not a factor for consideration in our system because profitability and viability of the industry is not a consideration, right? It's like the criminal law power is focused on public order and health and things like this and the protection of the public. And so I do think it's the wrong tool to regulate this industry, and I think it's going to make it harder for craft businesses in the future. If ever, you will never hear me give business advice, but my one piece of business advice is the criminal law power as your tool to regulate an industry is not good for business.
Yeah.
Yeah, I don't know. I think the concern I've always still been faced with is this distinction between recreational and medical. And so we've talked a lot about distribution and so on, which is mostly the rec market. I'm still concerned about their approach to the medical issue and how they seem to want it to just disappear and hope that everybody just goes to the rec stores. They don't, I think, really understand or want to understand the significance of its of cannabis for medical purposes and how it impacts different people in different ways and how important that part of it is, that is quite separate. I mean, many would say, oh, Conroy, all use is medical use. I think that's David Malmo Levine's favorite, one of his favorite expressions, and that may be true, but at the same time, until it ever gets to that stage where that's accepted, we have clear medical benefits for specific medical conditions, and we need to recognize that and educate the doctors more and support the doctors more, expand it so that naturopaths, doctors of traditional Chinese medicine, and these other people who know something about whole plant medicine so that they can be involved in it, and again, keep working to overcome the stigma of whole plant medicine. And we now have the many variations that people make from the product, so that isn't so that are extracts and there are different things that are more like pills, I suppose, that people are used to in terms of medicine. But I think educating the public and continuing to have them understand the importance of this and the no lethal dose. I mean, the opiate crisis, we have, Neil Magnuson down there and others in the downtown east side, running the Cannabis Substitution Project, and we've got applications into Health Canada to have them exempted from certain regulations to enable them to supply the homeless, to supply the people who don't have, regular doctors and so on, because we know that cannabis is a fantastic substitution for opiates. We know from the National Academy of Science, Engineering, and Medicine report in the U.S. that surveyed all the different medical issues and so on, that chronic pain, that it is conclusively effective for chronic pain, notwithstanding all the problems in doing the research. Well, most or many of these people are addicted to opiates either because their doctors overprescribe them and are going to cut them off, so they go to the street to get it. They don't want the doctor to know. They're dying in their homes. They're not dying on the street, many of them. And so, he's involved with his group in life-saving efforts to provide quality cannabis to people as a substitute, a non-lethal dose substitute for what they are using, and ending up with fentanyl-laced stuff and so on the street. So I think that's a major focus that we need to realize, that, overcome this reefer madness nonsense. It's helping people, saving lives. Help get it to them as a quality product. Don't, he was in a place, he gets kicked out of the apartment because of Vancouver city bylaws and stuff like that. So he's rolling around in a mobile, which isn't exactly the best. But, we have limited deaths in that area of the downtown east side. Many of the deaths are apparently happening in various places throughout the province and small towns and so on. So, even though it's still a big problem in the downtown east side, they are a number of groups doing the same thing and being very effective. So I think that's another area that we need to focus on.
So on that note, we have a question from Stacey Johnston, and she asks, are there formal public education efforts taking place at any provincial or federal level? Do you either of you guys know of anything of that nature going on?
I don't think so, other than what they put out on their web pages and stuff. I don't know. I mean, at one point there were some things, but none specific that I know of that are being run by government. I mean, they'll do consultations on various things when they're planning to make a change, and like the guidance document. But I don't know. Jack, do you know of any others?
I think there's a fairly significant effort from government to reach out with information campaigns, but I come off sounding like a conspiracy theorist or something, but like, I'm often deeply troubled if the government's the sole source of information about the cannabis plant and how it's regulated, right? Because the government has a position on the cannabis plant and how it's regulated that stands quite often in very stark contrast to the knowledge and experience of the cannabis community itself. So, like as far as education goes, I think it's actually kind of contested ground with levels of truth that differ between sort of lived experience, like what John is describing, and the great litigation work he's done on behalf of, say, the Cannabis Substitution Project, who are saying, look, we've got empirical data that low cost, low barrier access to medical cannabis helps opiate addicts stay off of opiates. That saves lives, right? That's their position. The empirical data supports that. The federal government's position is, this is crazy, cannabis is harmful and it hurts people, and probably more people are dying because they have access to cannabis, right? And so who's correct, right? Because these are polar opposite positions. So, the source of the information in regards to cannabis, I think, is of the utmost importance. So as far as like government education campaigns, but I would say that, for the cannabis community, our lived experience is worth interrogating and worth looking at. So beyond that, I would say, don't trust the government.
Well, it's this fear. They have this fear still, or some of them have this fear still, thinking that they're somehow protecting the public by this. It's just, bizarre. But then I'm afraid I've seen some pretty bizarre things in my time. Over the years.
I just did a hearing where we were arguing this, and I can say this because it's public record, but I said, like, they said, well, look, we have to protect public health. So, this cannabis was dangerous because it was unlicensed cannabis. And I said, yeah, but like, what evidence do you have that this is any more or less dangerous than cannabis that came from anywhere else? I said, like, shouldn't you have to tie an assertion of harm to like some empirical data or information? And I was told that, stop saying crazy things, Mr. Lloyd. But I'm not wrong.
I think the best one is that illustrates the ridiculousness of the situation, are the business about how you don't want people to see the plant. And I keep saying, what happens when you see the plant? I mean,
you just go crazy.
I got poppies growing out there. I've got all kinds of other things growing out there. What happens when you see a cannabis plant? Is there something particular that happens? Especially if you're a young person who walks by a store and there's no opaque. They might see a cannabis plant. My God, what's going to happen?
And it's so funny just knowing human behavior. The fact that you stop someone from looking at a cannabis plant makes it so much more beautiful and attractive to a young person.
Exactly.
For me, it did.
Well, I mean, they don't understand human behavior. And again, I go back to the prisons, where the more intense they try to be to stop people from doing things, the more ingenious human beings are to figure out ways to get around it. And the prisons are a classic in terms of how they get messages to different people, how they do things. I mean, it's a book in itself in terms of, and they clamp down. Well, there's a way to figure out, so we're going to clamp down. So, human ingenuity, they don't understand how great it is.
So we have two last questions, and I'm going to combine them into one question because they are very related to each other. Nicholas Wong asks, what changes to the legal framework are coming in the near future? And David Hutchinson asks, is there a legalization 3.0 inbound to permit additional delivery methods for medical patients and or higher daily limits or equivalencies for edibles used in adult use market?
Well, hopefully they listened to the ruling in Howell, which is unappealed, which said that, arbitrary restrictions on potency, it's similar to Smith, really, but arbitrary restrictions on potency violate Section 7 of the Charter. And then beyond that, I think we do have to be alive to the fact that the Health Canada public statement that closed earlier this month is indicative that quite likely an increased assessment of potential public health issues related to proposed cannabis gardens may be inbound within the next, I would say, 18 months, but possibly 12. And
what does that mean
maybe
exactly? I'm not sure I'm following what you're expressing there.
Well, again, it's what I describe as unfettered discretion on the part of a bunch of unelected mandarins that decide who gets to access their medicine and who doesn't. John describes it in a much more polite and good way. So I'm the conspiracy
I like
theorist.
the way you describe it.
But I do think that, you know, when I read it, I think that there's going to be a real focus on high gram per day licenses. I think that there's going to be a real focus on who is applying for the license, and I think that there's going to be a real focus on what the garden looks like. And I think that folks need to be ready for that, and either they need to be ready for that from a litigation perspective, or they need to be ready for that from a compliance perspective, saying, look, I've done good electrics, I've done good doors on my premises, and everything is really safe. And hello, David Hutchinson. I haven't seen you in a while. I hope you're doing good.
Yeah, I'm not sure. I mean, I think, the changes, possibly that because of this guidance document, as Jack was just talking about in terms of the medical, that we may see some things there. I certainly don't see any major changes coming to the Act itself for a while. And again, any changes are likely forced by us in the courts more than them choosing to do it voluntarily. I mean, I hope that they get better and better at rolling things in. But based on my past history, I'm not holding my breath, as I say. And, you know, I don't know. I think we're just going to have to keep being there, ready to deal with issues as they come up, and hope that as time goes on and as people get more and more educated and more overcoming their fears of public safety, public health, that we roll in. But again, it's going to be interesting to see what happens in the U.S. There's finally more movement going on down there, and we may be in a situation where finally it's federally changed down there. And again, the more countries that do it, the more people are educated about it. Eventually, that's what it's going to take, I think, in order to finally, hopefully, in maybe not my lifetime, but in some of your lifetimes, it'll be what it's reasonable.
Yeah. Cool, guys. Well, thank you so much for being here today. Before we wrap things up, I just want to extend an invitation to each of you. Are there any last things you want to share? Any last words you want to say that you think are really relevant for the conversation that we've had today that we haven't really touched on yet?
All I would do is put in a plug for the BC Craft Co-op, which we haven't mentioned, which is a way for craft growers to join an organization with people who have common interests, common issues, who can work together, economies of scale. It's better as a group to be able to lobby governments to change things and so on and so forth. So I really, government brought in the standard licenses, then to their credit, the micro to try and deal with it. But as we know, the micro just is still all kinds of problems for the craft growers. So we need to get the craft growers in, and the co-op is one way for people to do it. And so I would encourage the establishment of co-ops across the country for the small craft growers to get in there and to be able to provide us with the great product that the craft producers have always.
And serendipitously enough, our very next episode will feature the BC Craft Farmers Co-op. We have Sophie Mass, one of the main founders of the co-op, and David Herford, who has background in legislation and is also one of the main people spearheading that project. And they'll both be joining me for episode 5. So please do come back in 2 weeks to see what their perspective on the legal craft cannabis industry is.
All right.
Jack, anything you want to share before we wrap up here?
I don't think so. What a great pleasure to hang out with you guys. Really fun. And as always, I learn a lot when I get to do something with John. So this was absolutely wonderful.
I'm depending on you to keep me up to date on what's going on as I get semi-retired.
Well, thank you guys
John and
so
I
much.
share an office, if anyone doesn't know. So we're lawyer buddies now. It's like the greatest experience for me is like all these lawyers that I just worshipped, and now I get to work with them. It's so cool. So I just feel very lucky.
Well, I'm glad you're getting to, it sounds like you're living out your dreams there, Jack. Would you say that's correct?
Absolutely. Yeah, no, I'm very fortunate. Yeah.
Oh, that's wonderful. I wish that everybody in our world gets to realize their dreams. That's such a wonderful thing to be able to realize in your life.
Thank you.
Yeah, for sure.
Well, thank you guys so much for being here. You guys were a wealth of knowledge and, very approachable and kind people. Really appreciate you taking the time to share all that you did here with us today and this discussion that you were part of. Nick has shared a link to the next episode with the BC Craft Farmers Co-op if anybody wants to register for that. And yeah, thank you all so much for being here. It's a pleasure to host these things. And like you, Jack, I learned in my one conversation with John now, I've learned so much as well. Actually, that's not true. John, I emailed you like 3 or 4 years ago when I was researching something, and you were kind enough to send me a very thoughtful and detailed response and help me understand something about a case that's taken place a while back. So 2 for 2 now.
Well,
Thank you, everybody. I'm gonna hit the end event button here, and this discussion will be pretty much immediately within like 2 or 3 minutes available for rewatching for anybody who's registered. Anybody who missed it, you can send them the same registration link, and it'll be available for free for them, and then it will go on to our YouTube channel in about a couple weeks. Thank you all so much, and I hope you all have a wonderful rest of your day.
Thank you.